are pleased to have Tresi Weeks here to impart some really important information. She was with us last year, and I know that people were riveted because they heard a lot of things that they had not heard before, and lots of concerns just as you have as your children age. And so I'm happy to have her here. She's a community advocate, a parent of a child with a disability as well, and she just has fabulous information that to share with you. And her cohort is Lena Carrera over there. Thank you, Lena. And
all right, thank you so much. All right, welcome.
Good morning.
Okay, everybody hear me okay? Very good. Welcome. What a great crowd. I'm glad you're here. My name is Tresi Weeks. I'm an attorney and owner of the Weeks Law Firm. And then Lena Carrera is also with our firm as well. So she's the one that helped coordinate this event, so we thank her a great deal. Our firm, we do wills and trust, probate, and guardianship. But we also do a lot of special needs trust. I would say half of our practice is helping families with children with disabilities. When my daughter is 21, her name is Jordan. When she was young, I was dealing with her own special needs. I got to know other parents, and I realized that we were all doing a great job of taking care of our kids now, but we didn't know what would happen if we're not around to take care of them. What happens when they become older adults? And so when I looked into this area of law, I found out that it is very complex, and that's why very few attorneys do special needs trusts. So if you are dealing with an estate planning attorney, make sure they are extremely knowledgeable in the special needs trust area, because just an estate planning attorney does not know enough to properly guide you. We're going to talk about two main topics today. The first one is special needs planning, planning for your child's future. Then we will talk about guardianship and guardianship alternatives. So how many of your children are under 14? Okay. How many of your children are 14 to 18? Okay, a majority of you. Any with children over the age of 18? Okay, so anybody have a guardianship already? Okay, so this will be good information for all of you. So we're going to talk about some frequently asked questions. We get a lot of questions about special needs trust, so we're going to talk about those questions today. We're going to look at some scenarios. Now, these are not real clients because of attorney-client privilege. I cannot tell you about real clients, but these are amalgamations of real people. So these are real scenarios that can happen. So let's imagine Izzy. Now, Izzy is a young adult, and she lives with her parents. She's receiving some government benefits, SSI and Medicaid, and we will talk about those programs in a minute. So Izzy has a great life. She has an online business, she has a blog, she has thousands of friends all over the world, and she truly enjoys her life. But her parents were so busy, again, taking care of her now, that they forgot to plan for the future. And so, unfortunately, her parents passed away. And I will tell you that, stepping aside from this a moment, the death rate for parents of kids with disabilities is the same as the death rate for other people. So what that means is we never know when it is going to be our time. Because I do handle probate, I've had 3 in the past year that were parents of kids with disabilities. So we really, we have no guarantee. I know that when my daughter was young, I would pray, Lord, please don't take me because I'm the only mom that this child has. But it does happen. We're not immune to that type of thing. So Izzy's parents passed away. Now, they weren't wealthy, but they had some assets. They had a home, they had some life insurance, they had some retirement accounts, some bank accounts. And so, because there was no will or trust, all of that went to Izzy outright. First of all, Izzy was not used to managing money and didn't really know how to manage that amount of money. But also because she inherited that, she lost her SSI and Medicaid. Now, Medicaid had been paying for a lot of services for Izzy. It had been providing for attendant care, for diapers, for all kinds of things. Her parents had her on their health insurance through their employer, but now the parents were gone. There was no health insurance through an employer anymore. So what that means is she lost Medicaid and SSI. Now SSI is a check for $735 meant for food and shelter. So not only did she lose that money, she lost all of her medical coverage. That meant that her parents' money had to pay for everything out of pocket. Everything. So 24-hour attendant care, diapers, all the services, the therapies that she needed, that was all out of pocket. Now, she might be able to buy some kind of an insurance policy, but it's certainly not going to cover all of those things. And usually they have a very large deductible. So the effect of that is that the money ran out because they had to spend about $100,000 a year. So that only lasted a certain number of years. So what happens at that point? Well, at that point, Izzy is destitute. She has no money. So she can reapply for SSI Medicaid, and she's eligible. But at that point, all she has to live on is $735 a month and Medicaid. And Medicaid does not cover all of the things that she needs. So unfortunately, she had no money to stay in her home. She was kicked out of her home. She couldn't even afford a group home. And so she ended up in an institution and lost her online business, lost her blog, lost all of her friends online, and she lived the rest of her life in an institution with no friends and a poor quality of life. I know that's not what her parents would have wanted. Now let's imagine Andrew. Now Andrew is a young man, again, he's receiving SSI and Medicaid. He's living in a group home. Now this group home costs more than what his government benefits cover, and so his parents pay that difference. But he likes the guys that he lives with, he enjoys his activities, really enjoys his life. Now, Andrew's parents knew that if they left money to him outright, that would affect his government benefits. So they said, well, let's leave the money to our daughter, Susan. Susan loves her brother, Andrew. We know she'll use that money to take care of Andrew. So the parents leave, parents pass away, and the money does go to Susan. And Sister Susan lives in California, and she's married and has her own kids. So sure enough, Susan loves her brother. She uses that money to take care of him. But then Susan died. What happens when Susan dies? Well, that money is in her name. That's part of her estate. So that means that that money was distributed according to her will. And her will left everything to her family, her husband and her children. Now, her husband did not have a relationship with Andrew. He didn't know what Andrew's needs were. And so he knew that his kids needed college. So all of that went to Susan's family, nothing to Andrew. So what is the effect on Andrew? So again, from that point forward, all he's living on is $735 a month and Medicaid. So that means he could no longer afford the group home that he enjoyed so much. He was put into a government group home. He didn't get to choose who he lived with. He was living with people that had behaviors that were contrary to his type of behaviors. So he lived the rest of his life not in a good place. He lost his friends, lost his activities, and again, did not have a good life. Now let's imagine Kyle. So Kyle is similar to Andrew in that he is also living in a group home. Again, that costs extra than what the government provides. He has a part-time job and he has friends. He loves his life. Now his father knew that if he left money to him that Kyle would lose his SSI Medicaid. And so the father went to an estate planning attorney and got a special needs trust. Now, when you create a trust, you have to name who is going to be the trustee, who is going to manage that money. So the father's brother was a CPA. Now, he lived in another state, but he thought, well, he's a CPA, he can handle that money well. So when the father died, the money goes into the special needs trust for Kyle. But now we've got an uncle, we'll call him Uncle Bob. Uncle Bob is now managing the money, but Uncle Bob doesn't really know Kyle. He's not here. He doesn't know that Kyle likes the home where he's living. He doesn't know that he likes his job. So he's just looking at the numbers, and he says, this group home's too expensive. So one of two things can happen. Sometimes Uncle Bob makes him come live near him in that other state. So that means he loses all of his friends, his job, everything here, and has to move to another state. Or even if he gets to stay here, Uncle Bob might say, well, you can't afford to live in that group home. I'm going to move you into a group home that doesn't cost more than $735 a month. So either way, Kyle lost the buddies that he liked. He lost his job, all because his trustee did not really know him well. So when we do our planning for our families, we consider all of these things. And so we'll talk about some remedies of how we can prevent these tragic endings from happening. And I do ask that you keep the questions to the end, because I may answer your question during that time period. So let's look at the government benefits and what government benefits are going to be available. We're really looking at SSI and Medicaid. SSI is supplemental security income. And of course, Medicaid is basic health care plus some other services. But your child has to be disabled, sufficiently disabled to receive these, and they have to be financially eligible. To be financially eligible, your child has to have less than $2,000 in monthly income and less than $2,000 in countable resources. We know that $735 a month is not going to be sufficient for our child to live. We know that we want to leave money to our child if we pass away. So how do we do that? So again, SSI is, right now it's a check for $735 a month that is meant for food and shelter. And Medicaid, of course, is the basic medical care. So let's look at the monthly income requirements. So for Medicaid, the child cannot have more than $2,000 a month in income. If they're on SSI, they need to keep that income below $1,100. Now, what the Social Security Office, the Social Security Administration, I'm going to call them the SSA. What the SSA considers income is different than what you and I would consider income. And it's different from what the IRS defines it as income. So income obviously is if your child is working, but it's also if cash is given to your child. That's considered income. Now, because the SSI check is for food and shelter, if somebody else is providing food and shelter, that is considered income to the child for SSI purposes. Keep in mind that SSI purposes are very different than IRS and income tax. And we're not talking about IRS and income tax. We're just talking about eligibility for these government benefits. Now, when the child is under 18, the income and resources of the parents are deemed to be the income and resources of the child. So if the parents are not indigent, then the child cannot receive SSI prior to the age of 18. Now, there are some Medicaid waiver programs that children can receive under 18 in which they do not deem the income and resources of the parents against the child. Are any of your children receiving Medicaid waiver services? Okay, so we've got a few. If you're not on those lists, you need to be on the waiting list for those, because the waiting list for some of those programs is 15 years. So you want to make sure your child, and if you don't know what I'm talking about, we can talk about that later. You want to make sure your child is on that list, even if you're not sure if they need the programs or not. Because whenever their number comes up, we can look at that point and determine, are they eligible and do you need these services? Now, I said that if somebody else is providing food and shelter, that's income to the child. They have a special way to deduct that, because if you're, typically you would reduce the SSI check dollar for dollar for any income. But for food and shelter, they have a special rule where it would only reduce the SSI check by 1/3. So instead of reducing the SSI check dollar for dollar for the value of the food and shelter, then it can be reduced by just 1/3. So you would lose about $250. The SSI check would be reduced by that. Now, the biggest thing I want you to know about this is that if the child is paying rent according to a rental agreement, then the SSI check is not reduced by 1/3. So when your child applies for SSI, make sure that you tell the SSA that your child is going to pay you rent of $300 or $350 a month. That way, the SSI check is not reduced by 1/3. Now let's look at countable resources. So we were talking about income, now let's look at resources. This is what I would consider assets. Countable resources cannot be over $2,000. There are some assets they don't count. They don't count a home, one car, and personal belongings. So they do not count computers and those types of things that your child owns. So if your child is an adult and they have one car or they own a house, that's not counted. Everything else is counted. So usually we're talking about bank accounts, annuities, and things like that. Now in Texas, if someone is receiving at least $1 of SSI, they automatically get Medicaid. So that's the main way that people get Medicaid services. So in some instances, it's okay to have the SSI check reduced as long as they're still getting some. So again, if your child's going to work, we have to look at those numbers to make sure we don't want your child to earn too much. But there are some ways we can do it, because earnings, if they actually go to work, only reduce the SSI check 50 cents per dollar. So if your child earns $600, only $300 of that is counted against your child. So, but there are ways we can work to make sure that your child maximizes what they receive. Now there are 40 different Medicaid programs in Texas. We talked about Medicaid waiver programs. There are different eligibility requirements for each one. So if your child is on one of those programs, then we need to look at the statement you get from the government that shows exactly what they're getting, so that we can make sure that we are planning correctly. Now, when we are doing estate planning and special needs trust for a child, if they're under 18, we may not know what programs they're going to be eligible for. So we're just planning based on what we know right now. So usually we don't have to consider all of these 40 programs if your child is not already receiving those. I want to differentiate between programs that are not based on financial need. The first one is Social Security Disability, or SSDI. It's completely different than SSI. Social Security Disability is based on the fact that someone contributed to the Social Security system a sufficient number of quarters and then they became disabled. So you as a parent, part of your paycheck part of it's taken out for Social Security. So if you later became disabled, you would be making a claim based on the fact that you contributed into the system. So Bill Gates can get SSDI. Doesn't matter income for that. Now Medicare is health care for people over 65, and then sometimes for people with disabilities. Again, Bill Gates can get Medicare. So it's very important when you're looking at what services your child is receiving, that we know exactly which program it is. Now I will tell you that when the parents start taking Social Security retirement, your child's SSI check might convert to a Social Security check. So right now it would be coming from the SSI bucket. When the parents start taking Social Security retirement, or if a parent dies, that money's going to come out of a different bucket. So if that happens, just be aware that that's going to happen, and you may want to talk with somebody about that when it does. Is your child going to need government benefits? A lot of times we have children that maybe with autism or different things, and we don't really know if they're going to need benefits or not. My daughter's 21, and right now she's kind of working part-time, but she's not receiving government benefits. So, but I want to keep that option open for her, so that if some point she needs government benefits, she would be eligible for that. We don't know what programs are going to be available years from now. We don't even know what programs are going to be available by the end of this congressional session. So we want to keep our options open for that. And then you also may ask, does my child really need $735 a month? And I would tell you it really does help. It helps you leverage your assets so that your money lasts longer. Some parents, if they truly don't need that $735 a month, some parents will use that to buy life insurance on the parents. So when the parents pass away, a significantly larger amount goes to the child. So let's talk about special needs trust. So what makes a special needs trust so special? Again, we know government benefits are not going to be sufficient to care for our child. We want to leave money to them when we pass away, but we don't want them to lose their benefits. So the way we do that is with a special needs trust. And if you leave assets to the special needs trust, it's not counted against the child for government benefits purposes. So you can leave an unlimited amount of money to this trust. It must be properly drafted. And even if it's properly drafted, the distributions have to be made correctly. And we'll talk about those in a minute. But the result is that this money supplements the government benefits instead of supplanting those benefits. So what is a trust? I know a lot of people think a trust is just for super wealthy people. It's not. A trust is a document that we create that sets out what people will be involved with the care of your child. It will set out the money, how the money is used for your child, who will be taking care of that money. But also we're going to create a whole safety net team, because a trust in and of itself is not going to be sufficient to care for your child. We want a group of people making sure that your child's taken care of. So, could government benefits be a tool to assist your child? It might be. Even if your child does not need government benefits, could they manage the money on their own? In my situation, no. I would never let my daughter manage a significant amount of money. So she's going to need a trust anyway. So the way I've drafted, so my husband and I have a trust for her, and we've drafted it with flexibility so that if she's not receiving government benefits, it operates as a regular trust. If she is receiving government benefits, it operates as a special needs trust. So we've got flexibility built in. Also with our trust, it also provides from advocacy and protection. So if your child is not going to be able to advocate on their behalf, we have some safety features built into the trust. So the trust is not just for the purpose of qualifying your child for benefits. There are a lot of other reasons: management of that money for your child, advocacy, and more of a safety net team. How does your money get into a special needs trust? Now, typically when we're doing these trusts for parents, this trust is going to be like an empty bucket. So the trust for our daughter has nothing in it right now. There may be reasons that you put money in it now, but typically in the situations we're talking about with you, it may not have money until both of you pass away. So what we would do is in your will, we provide that whatever goes to that child goes to their special needs trust. So the will has to be drafted in the right way. Life insurance. Life insurance is a great way to provide for the care of your child. When we look at how much is it going to cost to care for your child, sometimes we would refer you to a care manager or someone who can come in and do an assessment of your child and determine how much is it going to cost for your child's care. Because keep in mind, if both parents pass away, you've got to pay somebody for everything that you are doing for your child. Attendant care, transportation, housing, all of that. So life insurance is a great way to do this. And what we do is when our clients do prepare a special needs trust, we have our clients bring into us the beneficiary change form so that we can make sure the trust is named properly. So for my husband and I, our primary beneficiary is our spouse. Our secondary beneficiary is our daughter's trust. We only have one child. If you've got more than one child, then we may have a separate trust for the other kids. And again, we would name those trusts as your secondary beneficiaries. You really don't want to name your children outright as beneficiaries of life insurance unless they are significantly older and would be able to manage that money. Retirement accounts, you've got 401ks, IRAs. there is a special way that we can name a special needs trust as a beneficiary. So it's fairly complex, but we do have a certain retirement plan trust we can do that doesn't disqualify. Now, child support. I just gave a presentation to the family law section of the Dallas Bar Association. If the parents are divorced, it is possible to have child support ordered beyond the age of 18 if the child is disabled. Now, child support is considered income to that child. So once that child's 18, 100% of that child support is considered income. So we have to do a separate special needs trust, and we have to make sure the divorce decree or the support order orders that child support goes directly into this special needs trust. That way it does not disqualify the child. So that's crucial for families. And with the child support beyond the age of 18, sometimes it's one parent supporting, sometimes it's both if the child's not living with either parent. So this just shows the funnel. Will, life insurance, retirement, all of those things would flow into the special needs trust. Now let's talk about your IRAs and 401ks. When a child inherits an IRA or 401k, they have two options. One option is they can cash it out within 5 years. When they do that, they pay income tax on that whole amount because your IRA and 401k has been growing tax-free. So somebody has to pay tax at some point. If they cash it out, they will pay income tax on that whole amount. So if you have a significant IRA or 401k, that could put your child in the highest income tax bracket. They would pay income tax based on their bracket, but that's added to it. The highest income tax bracket right now is almost 40%. So if you have let's say you've got $1 million life insurance for you and your spouse, your child would have to write a check for $400,000 to the federal government to use as they see fit. Not a good option for most people. Now, an adult child would have another option, is they can use that IRA and put it into an inherited IRA for that child. This is called a stretch IRA. What this means is that money can continue to grow tax deferred for your child's lifetime. So that means tax-free compounding because that account is earning interest. They're not paying tax on that, and then that interest is earning interest and so on. What that means is that money can grow significantly. Now, there are required minimum distributions to your child, and they don't start at your child's retirement age. They start immediately as soon as your child inherits that IRA. That required distribution is based on your child's life expectancy according to the IRS chart. So if your child is 20, the IRS chart may say their life expectancy is 50. So 50 years. So that first year, their distribution would be approximately 1/50th of that account. The next year, it would be approximately 1/49th, and so on. What that means is the distributions are very small at the beginning, and then they grow larger over time. Your child pays income tax on that required distribution, but because it's small, they're not in the 40% tax bracket, so the tax hit is much smaller. So I went on the Schwab website, and they have what's called an RMD calculator for a beneficiary IRA. RMD stands for Required Minimum Distribution. So I plugged in some numbers on this. Your numbers, of course, would not be exact. This is just to illustrate a point. So if we had a client with an IRA of $1 million, so let's say the client was born in 1960. Let's say that the child was born in 2000, and then the parent died this year. The blue on this chart shows how much that money could grow because of tax-free compounding. The light green you see on the top is the required minimum distributions. You can see that those distributions are very small at the beginning, and then they grow large as they go on. Now, according to this Schwab website, that $1 million would grow to almost $5 million. Now, again, keep in mind these are not your exact numbers, but the purpose of this is just to illustrate a point that if your child does an inherited IRA, they're not paying 40% tax off the top. They're not losing $400,000. They're going to end up with significantly more because of that tax-free growth. And then the tax hit is smaller, especially at the beginning, because the distributions are smaller. So, we talked about income to our child. Those required distributions are considered income for SSI and Medicaid purposes. So what do? We have a specialized trust, a retirement plan trust, that qualifies for this tax-deferred growth. A regular trust does not qualify for that. The trust that we draft complies with the IRS requirements for a stretch IRA. So you get the benefits of a stretched IRA with the protections of a trust. And then we have that trust operate as a special needs trust. The way we do that is those required distributions are not required to be immediately paid out to the child. They can be accumulated by the trustee. So the trustee would just put those in another bank account, but they don't have to be immediately paid out. That way, those are not considered income distributions to the child. So it's a bit tricky. For some clients, this is worth doing because for some clients, the IRA or 401k is their largest asset. Question number 4, what can the trust funds be used for? So let's say that parents have passed away. There is now money in the trust. What is it used for? First, let's talk about what it cannot be used for. You cannot give to the child cash, or you cannot give cash to the caregiver. So you also cannot give them a debit card. That's considered cash. Cash and debit cards are considered income to the child. You also don't want to use it to pay for anything that the government benefits are paying for. So if Medicaid is paying for something, don't use the trust for that. Other than that, it can be used for everything that your child needs. So again, all their personal needs, recreation, social, entertainment, education, medical, their therapies, everything that makes their life good. Really everything that you are using or that you are paying for now, the trustee can usually use it for that. Now we talked about a trustee. So when we create a trust, you are the trustee initially. That means you can amend the trust, you can revoke it. If both parents are creating this trust, then both of you are trustees, as long as one of you is alive. Who is going to be the trustee when both parents pass away? What the trustee does is they would make sure the money is invested safely, and then they would make distributions to your child. They have to make sure that they distribute it properly. They cannot give cash to the child, so they have to be willing to obtain legal counsel on how to make distributions correctly. They also have to keep good records. They have to make sure a tax return is filed on behalf of the trust. So they have to agree to engage a CPA to do those kind of things. So who is that going to be? And that's going to be different for every family. Of course, you want them to be reliable, have good integrity, be able to keep good records. For some people, that's a family member or a family friend. There are also professional corporate trustees. These are trust departments. And there are several in the Dallas area that specialize in special needs trusts. So they know exactly how to make distributions without affecting benefits. Corporate trustees do charge a fee, and you're usually looking at least 1% of the trust assets per year. They usually have a fee schedule that they charge. So for some people, a corporate trustee is a good option. If you have several children and you're going to name one of your other children as the trustee, think about how that would affect the relationship between the two children. Because in my mind, the relationship is more important than the money. So if that would affect the relationship between siblings, you might consider whether you want to do that or not. Now, the Arc of Texas has what's called a Master Pooled Trust, P-O-O-L-E-D. This is a big trust with a bunch of sub-trusts. And people can join this trust and create their own sub-trust. And in that situation, the Arc of Texas serves as the trustee. So again, you're going to be paying them a fee. But for some people, again, this is a good option. The Arc of Texas is really good for smaller trusts. They have a joinder fee. You don't have to have a separate standalone special needs trust. You just join their trust, and I think it's maybe $600 to join. So for people, so if you've got a trust of, so let's say 30,000, this might be a good option for some of you, or even below 100,000, because if you have nobody else to serve as a trustee, corporate trustees are not cost effective for trusts below about 250,000. But for the Arc of Texas, that might be a good option as well, because you get professional management, but then it can be for the smaller amounts. We've had a few times where a client inherited life insurance or retirement or something from an aunt or uncle or something, and it wasn't enough to justify creating a special needs trust. So sometimes we'll do this. Now, in the trust, we may also help you create what's called a trust advisory committee. So this can be a group of 3 to 5 people who are involved in your family's life and your child's life. And we can give this committee different powers. If we have a corporate trustee, we may give this committee power to hire and fire that trustee, because we know that the trustee we've named now is good. We know it's a good trust company. But what if they get bought out by a big bad bank and they don't do a good job, or their fees are too high? We want the trust advisory committee to be able to choose a different corporate trustee. So sometimes we give them that authority. Sometimes we give them authority to help advise your trustee. So if you'll remember our scenario with Kyle, so Uncle Bob was the trustee, but he was in another state. If we'd had a trust advisory committee, we could have had people here on the ground with Kyle who could have reported back to the trustee and said, "Trustee, Kyle really likes where he lives, he likes his job. Let's see if we can keep him in this group home and not move him out of that home." So they can help advise the trustee on distributions. Now the trustee has ultimate authority in how to make a distribution, but you can just have a group supporting that trustee. So the burden's not just on one person. You've got several people that can help with this. So sometimes we call it a best interest committee. So we don't do this in every case. It depends on your family and whether you need that. So for my family, that could be, my brother, my sister-in-law, one of my nieces. So there could be people like that involved. And the trust does provide for how successors are chosen, because if the people you've chosen are no longer living, there is a way to choose others. So this is what I talked about creating a safety net for your child. If you don't have a support system now, I really would encourage you to start creating a support system now, maybe church friends, or reaching out to nieces or nephews, whatever it is, trying to get a support team in place. They don't do anything, typically, this committee, until both parents pass away. So they're not an active committee. They're usually not required to meet a certain number of times. So really it's fairly flexible as to how that operates. What happens if you die without a special needs trust? Well, in some instances, let's say you leave everything to the other children, and we've seen this happen, like with the scenario with Sister Susan. You leave money to other children, or you leave nothing to that child. We had a case recently where the clients had an estate plan done by a very good estate planning attorney, but that attorney told them, well, don't leave anything to your special needs child because they'll lose benefits. They didn't realize that means that child's going to live on $735 and Medicaid the rest of their life. So it doesn't make sense to leave nothing to that child, because they will not be self-supporting. Your other children may be self-supporting. So you also want to look at that in determining how much do you want to leave to that child with special needs. Again, every family is different, but you don't have to leave equal shares to your kids if you don't want to. So if you leave nothing to that child, then all they live on is $735 and Medicaid. They will get no extra services, probably end up in some kind of a government residential facility. If you leave the money to them outright, then they lose SSI and Medicaid, and then your money has to pay for everything for them, because they've lost your health insurance as well. Now, could they buy a health insurance on the open market? Maybe. That'll cost spouse money. What will that cover? Probably not much. So your money's not going to last your child's lifetime, potentially, if you leave it to them outright. Again, leaving it to other family members. In our scenario where the money was left to Sister Susan, there are a lot of things that can happen to that money if it's left to another family member. We saw in that scenario Susan died and it went to her estate. But also, what if Susan filed bankruptcy? That money could have been lost. Or let's say Susan was in a car accident and got sued and there was a huge judgment against her. They could take that money. Or let's say that Susan developed a gambling problem and gambled that money away. So that money is subject to being lost. So usually it's not a good idea to leave it outright to another family member. Instead, just name them as the trustee, and that way when they die, you have named a successor trustee to step in and take care of them. So we know that you need a special needs trust. What else do you need? First of all, you need a will. So when we help clients, we do a whole package for our clients that includes a special needs trust, a will for both spouses, because that will is going to state that whatever goes to that child goes to the special needs trust. You also want to designate who you would want to be your child's guardian if both parents pass away. Because if both parents pass away and your child is sufficiently disabled to need a guardianship, then you want to choose who that is. Because if you don't choose, the court will choose for you. And it may or not be the person that you want. So you want to choose someone with the same values that you have. We also want to change your beneficiary designations to make sure the trust is named properly. So again, our clients provide us with those forms for life insurance and retirement so we can make sure the trust is named properly. And then we also want to consider coordinating with other family members, because we've had situations where a grandparent died and left money to this child outright, and that affected their benefits. So when we do a special needs trust, we give you a letter that you give to grandparents or other relatives that says, if you leave anything, so in my case, if you leave anything to Jordan, don't leave it to her outright, leave it to this special needs trust. Now, grandparents may not have a specific gift to your child, but if they have a will or a trust, it probably provides that if you die before the grandparent, your share goes to your kids. That's when we've seen it come to the kids without a special needs trust. So even if the grandparents don't have a specific gift to your child, they should add an amendment that says, oh, by the way, if anything goes to Jordan, it goes to her special needs trust. ABLE accounts. Has anybody heard of ABLE accounts? Nobody? Okay. ABLE accounts is a new law. It's a federal law, and then Texas also passed a law approving ABLE accounts. ABLE stands for Achieving a Better Life Experience. This allows someone to open an ABLE account and save up to $100,000 without affecting their eligibility for SSI and Medicaid. So this is a big change. It's supposed to be able to allow that person to save money so that they're not completely destitute. The money has to be used for disability-related services for your child, and we'll talk about that in a minute. The biggest thing with ABLE accounts that people don't understand is that it has a Medicaid payback provision, which means that when your child dies, whatever is left in that account goes to Medicaid to pay them back for whatever they have spent on behalf of your child from the date of opening up that ABLE account. So you need to be aware of that. It may not be an account where you want to accumulate a whole lot of money. You may want to use that money first. An ABLE account can be established by a person who was disabled prior to the age of 26. If they've been determined disabled by the Social Security Administration, then they qualify. But even if they have not, you can still open an ABLE account, but you have to submit documentation from a doctor or something that says they're disabled. There is no government entity that is given the task of determining if somebody's eligible for an ABLE account. So usually the ABLE account administrators just say, hey, we need some kind of a letter or something to show your child's disabled. So it's pretty broad. It's easier to qualify for an ABLE account than it is SSI and Medicaid. Now, each state is allowed to start their own ABLE program. Texas has not started their own yet. Now, ABLE programs are like 529 education accounts. In fact, it's in the IRS code is 529A of the IRS code. So these are programs administered by states. So they're not in a bank account. These are state programs. Now, there are several states that allow non-residents to open accounts in their state. The one we typically use is Ohio. I know the director of the Ohio ABLE account. It seems to be very well run. I wouldn't choose a state that has the lowest fee, because if they've got the lowest fee, that means that program's not going to be self-sustaining and it's not going to be there forever. So Ohio ABLE account, so you can just Google Ohio ABLE account. I think it's called stable.org or something, I'm not sure what it is, but go on there, you open the account online, and there is a modest fee for that, and then you have some limited investment options for that money. You can open it, or the individual, your child can own it. But under the law, your child is considered the owner, regardless of who can sign on that account. So you may have an account for your child that only you sign for, but your child's considered the owner. The child can only have one ABLE account in the whole world, just one. You can't open more than one. Anybody can contribute to it. So other family members or somebody else can contribute to it. But there's a limit. Right now, only $14,000 per year can be put into the ABLE account. So if you've got grandparents or somebody putting money in, make sure the whole total for the year is not more than $14,000. Next year, that goes up to $15,000. Now, for SSI purposes, you cannot have more than $100,000 in it. If you go over $100,000, the child's SSI is suspended until you get below that $100,000, but they still qualify for Medicaid. So some special rules there, but you want to make sure you keep it below $100,000. If they're not receiving SSI, they can save up to $370,000 in Texas. So the money has to be used for disability-related expenses. This is a fairly broad definition, so it's not as strict as some other distribution standards. It can be used for, again, education, housing, health and wellness, everything, assistive technology, even legal fees. So I guess lawyers wrote this because they put legal fees, the money can be used for legal fees. So really, everything for your child that cannot be used for you or other family members, but anything your child wants. Now, the interest on this account is not considered income for SSI purposes, and the distribution for the child is not considered income. There are a few little complications, but if it's for a non-qualified disability-related expenses, there are some penalties for that. You may have to prove to the SSA how the money was used, and we don't know that yet. One reason I like the Ohio ABLE account is they have a kind of a prepaid credit card that goes with that ABLE account, so that your child can use that card, and that way you do have a record that that money was used for your child. And let me go back to Special Needs Trust for a minute. We have talked about how the trust cannot give cash to the child or debit card. Typically what the trustee sometimes will do is that there will be a credit card issued for your child's needs, and then that trustee can pay off that credit card every month. All right, major drawback, again, the Medicaid payback provision for ABLE accounts. The money would have to go to Medicaid and pay them back for whatever they spent on behalf of the child from the date of the creation of that account. But keep in mind that the Special Needs Trust that you have created for your child does not have a Medicaid payback provision. So if it's your money, you may not want to put it in the ABLE account because it may go to the government instead of your family, because your trust you're creating, upon your death, that money goes to whoever you've named as contingent beneficiaries. So on your Special Needs Trust, you're going to say, in my case, if Jordan dies, then whatever's left is going to go to some other relatives I've named, or a charity or whatever. So just keep this in mind when we're planning. Now, when you research ABLE accounts, there is some misinformation on the internet, even from good sources. Some sources say that you can roll over from a 529 education account to an ABLE account. Right now, you cannot. The IRS is still writing regulations regarding the ABLE accounts. A lot of people are lobbying to allow you to do that because sometimes grandparents have set up a 529 education account and then we discover, oops, that child's not going to be going to college. It's only right that they should be able to transfer that over to an ABLE account, but right now they may not be able, they cannot do it right now, but we hope so in the future. So when is it good to use an ABLE account? Sometimes we have clients where the young person is working and they want to save some of their money. They can put their money into this account. Or let's say they get a small inheritance or gift from grandparents. And when I say gift, I'm not talking about $25 in a birthday card. I'm talking about $10,000 or something like that. You might want to put it in there. Keep in mind, though, there is that Medicaid payback provision. Sometimes grandparents will fund this. Let's say grandparents are funding 529 education accounts for every grandchild. And if your child is not going to go to college, and we know that, then they might fund an ABLE account instead. The really cool thing that we can use this for is for paying rent. So let's say that your child is living in an apartment or shared apartment or group home or something like that, and there's rent to be paid. With the Special Needs Trust, with SSI, if somebody is providing food and shelter, that reduces their SSI by 1/3. But what we can do is that you can put that money, you can put, say, $1,100 into the ABLE account. The ABLE account can pay that rent. That does not reduce their SSI check by 1/3. So this is magic in some situations. So, but keep in mind, you can only put in $14,000 a year. So you don't want to put in $2,000 every month because then that will cause a problem. So in some situations, this is a really good option for paying rent. So conclusion for ABLE accounts is it allows the SSI recipient to save money. They don't have to be destitute. It is a low cost. We consider it just another tool in our toolbox. In most situations, it's not a replacement for Special Needs Trust. It's just something we can do in addition to that. So when do you need to create a Special Needs Trust? I hear a lot of people say, well, we need guardianship before we need a Special Needs Trust. You need to create that trust before you die or become disabled. Does anybody know when that's going to be? Yeah, we don't know when that is. And so you don't need to wait till your child is 18 or guardian. You need to do it as soon as you possibly can. Sometimes we have parents coming in with a newborn that has a major diagnosis and we're creating a Special Needs Trust right then. So the sooner you can do that, the better. So what is the result of wise planning? What if we did this right? If we do, we've got a financial plan to care for the child. You may want to consult with a financial advisor who can help you maximize what you're leaving to that child. You may consider more life insurance or other things. But we also will have a support team in place. So we've got a trustee. We may have a trust advisory committee to make sure your child's taken care of. We've allowed your child to maintain eligibility for SSI and Medicaid should they need it, but the result is just well-being for your child. We all want the best life possible for our child, and this is one of the ways that we can try to achieve that. So let's go back to our scenarios, and let's look at what would have happened if those parents had planned properly. So with Izzy, what if her parents had created a Special Needs Trust? And their house and life insurance and bank accounts and retirement went into the Special Needs Trust. That means that she would have maintained eligibility for SSI and Medicaid. So she still would have received attendant care and diapers and a lot of those services through Medicaid. She would have received the $735 a month in SSI. That means her money would be used on top of what the government provided. That means that money could last for her whole lifetime. The result of that is she would be able to stay in her home, keep her online business, keep her blog, and keep her good quality of life. She would not end up in an institution. So this is what would have given the parents the desired result. Now let's imagine with Andrew. What if, instead of the parents leaving money to Sister Susan, what if they left it in a special needs trust for Andrew? And Susan was the trustee. Well, then when she passed away, there would have been a successor trustee named, and then that person would have stepped in and then used that money for Andrew's care. So he would not have been kicked out of his group home. He could have stayed with his buddies and still had the good quality of life that he had, that he wanted. And then with Kyle, now he had a special needs trust, but Uncle Bob was the trustee. What if there had been a trust advisory committee? People here that knew Kyle, they could have worked together, and they could have talked to the trustee and told him, you know, this is a good group home. These other group homes that are less expensive have these problems, so we want you to try to stay here. And then they could have advocated on behalf of Kyle, and then he could have stayed in his group home, kept his job, and kept his good quality of life. So we have a free ebook on our website. It's weekslawfirm.com/ebook. This is written for parents. It's about special needs trust. So feel free to download this. You can give the link to your your friends. Now we do have a sign-in sheet at the table. Our firm produces an e-newsletter every month or two. It's supposed to be every month, and I don't always get it out every month. But it has information about new laws, about special needs trust, changes in the law. And then we also get workshops like this at different locations or in our office. So if you know of anybody that would want to attend one of our workshops, you can forward that newsletter to them as well. And of course, you can unsubscribe at any time if you no longer want to receive it. So we are at 11 o'clock. Do we have any questions about special needs trust before we move into guardianship? Yes.